Welcome to Looking at Legal Stuff. Today we have 7 hearings, including 4 new updates, in a case with a couple where mom and dad have had 10 years of high conflict back and forth accusations that have led to 3 separate CPS reports and 3 different GALs. Now they're back in court yet again, with dad asking for adequate cause to change the parenting plan because he says his son is too scared to visit his mother and claims he's refusing to go. He wants a restraining order against mom until they can have a trial. Mom is very upset about not getting to see her son, and she claims dad is lying about everything. She says that none of the previous CPS reports or GALs agreed with dad's claims, and that nothing he's doing is in their son's best interest. It's just about slandering her to the courts. What does the commissioner think of their claims? Let's find out.
Mr. Derby, I think this is your motion for adequate cause.
Yes, Your Honor.
Do you want to address that briefly?
Well, he's been running away after he filed the CPS report. The last month he's been with me permanently. His mother has tried to come and get him, but he's just so deathly afraid to go with her that he's refused to go with her. He just seems really scared. I don't know what exactly is happening at his mother's home, but he's really adamant about not going there. So like this week, he was supposed to be with her, but he refused Friday. So he's been with me still. It just seemed like things got a little bit worse for him at her home after the CPS report was filed.
Okay. Ms. Hyatt, have you looked into this matter at all?
Your Honor, this is an old case. I was appointed, I believe, back in December,
Right.
and I did have contact with Destin at his school. It's been many months ago, so I don't. At that time, it was decided that there was not adequate cause, and so I set the whole matter aside. So I kind of dipped into it and then stepped back. I have no new information for the court today. I don't know how you want me to proceed.
Okay. Well, first of all, if I find adequate cause today, do I need to reappoint you, or do you think that the old appointment is sufficient?
Let me look at my orders appointing. I guess one change would need to be made. I was supposed to have a report filed by January 4th of 2023. So obviously I missed that.
All right, well, let's, all right. Well, let me make a decision on the adequate cause first.
Okay.
Earlier, I read the requirement for adequate cause. Again, that's at RCW 2609-260. And it's the court shall not modify a prior custody degree or parenting plan unless, and I'm skipping some of it, it finds that a substantial change has occurred in the circumstances of the child or the non-moving party, and that the modification is in the best interest of the child. And from what Mr. Derby has presented in his motion, I believe he meets that standard. So I am going to sign your order for adequate cause.
Thank you, Your Honor.
I'm going to do an amended appointment of Ms. Haidt as the guardian ad litem. And she will need to do an investigation that will assist the court in making a decision down the road. What will happen eventually, Mr. Derby, is this will be put on the trial setting calendar and set for a trial on the issue of the parenting plan. Ms. Height needs enough time to do a report before that. And so I'm going to keep this case on my docket for the time being so that I can at least track that report. I'm going to set a review hearing for April 12th at 9 o'clock. That will be simply for the purpose of determining if Ms. Height has met with the parties and whether she's got all of the documents she needs. I'm not expecting a report at that time, but I do want to make sure things are going forward. When it's clear that Ms. Height has completed her investigation, then Mr. Derby, I'll direct you to put this on the trial setting docket so you can set it for trial. Okay.
Okay, thank you, Your Honor.
All right,
In the meantime, Your Honor,
yes,
I'm just concerned. I'm concerned about my son and how he's absolutely just dead set on not going back to his mother's home. I was just curious if I know that the police have been called. He's ran away. He was even put on the runaway list. I just hope that we could keep him at home until this is found. It's hard to send him somewhere when he acts so scared.
what
It's fine. Okay, you got to be quiet.
I just let a couple people in. Is either of those Melanie Vianola? Doesn't appear to be. So I don't know that today I can change the parenting plan. Here's what I would suggest you consider is if you think the mother is a threat of harm to your son, maybe you should bring a motion for a restraining order, and I can consider that and perhaps put some restrictions in place.
Okay, Your Honor.
All right, but right now, based on what's in front of me, what I'm able to do is say, yeah, there probably is enough evidence here that we need to revisit the parenting plan, but I don't know that I can change the old one at this point. Okay.
Okay, Your Honor.
Okay,
Your Honor, if I might just ask one quick question.
sure.
If on April 12th, you're really looking for just a compliance review that the parties are engaged, and then do you have an idea that you would also like a report from me at a future date? And if so, do you have a timeline in mind for that?
Maybe you could help me with that. I would hope we'd have some type of report by, say, May,
Okay.
either mid-May or late May.
Okay.
Okay.
I may have some other verbal information for you on the 12th if I'm able to visit with the parties before then as well. But I'll for sure attempt to have a written report then on the date that you set for May.
Okay.
Thank you, Your Honor. I appreciate that guidance.
All right. Thank you.
Okay. The first case I'm going to call is 13-3001025. This is Donald Derby as the petitioner, Melanie Vianola as the respondent, and I believe we have guardian ad litem Ann Height with us.
Yes. Good morning, Your Honor.
Good morning. So what I believe we are here for, and some of you may know the typical judicial officer who's probably heard a lot of the matters in your case is not here today. So if I am mistaken, please correct me. But what I believe we're here for is to determine a restraining order. Looks like a temporary restraining order, emergency restraining order was signed. Does that sound correct to the party?
Can anybody hear me? This is Melanie, part of the
Yes, ma'am.
party.
Yes, we can hear you.
Okay, I'm trying to get re-logged in so I can see if I can get 1 second.
Yep, absolutely. We'll give you a minute.
Thank you so much.
So we'll just pause here for a minute while she gets logged back in.
Okay, I'm in. There we go. Thank you so much.
Yes, absolutely. And you said you are Melanie.
Yes.
Okay. So does that sound right to the parties that what the folks are prepared to proceed on today is whether this restraining order should be entered?
Yes.
Yes, Your Honor.
So what I will do in order of how we proceed is, Mr. Derby, I'll let you know what I have reviewed for filings. I'll let you make any arguments to the court that you want to. Ms. Vianola, I will let you respond. And then I am going to get input from GAL if there is input to give on this matter. Okay. All right, so Mr. Derby, what I do have is a motion for immediate restraining order that was filed on or about March 21, 2023. And I have reviewed that. And first, what I'll have you do is just raise your right hand and we'll swear you in for testimony that you're about to give. Can you raise your right hand? You swear and affirm that the testimony you're about to give on this matter is the truth, the whole truth, and nothing but the truth.
I do.
Right. Can you state your full name and spell your name for the record?
Donald Jeffrey Derby, DONALD JEFFREY DERBY.
And are the statements that you made in the, it looks like the March 20th petition filed on March 21st, are those statements true and accurate under penalty of perjury?
Yes, ma'am.
Okay, so go ahead and tell the court why you are asking for this restraining order to be entered.
Well, at this time, my son had been feeling so scared and he had been running away. He ran away 5 times. Twice the police were called. One time he was put on a runaway list. The things that he says that had been going on in the home, he's a 15-year-old boy who's over 200 pounds, and he was saying that he was scared all the time, and if they weren't yelling at him and doing whatever was going on, they were fighting with each other. There's a constant feud going on. He'd been getting slapped, punched. He had shoved against the wall. Things were being thrown at him. And he was always saying that if they get around alcohol, then things get even worse. So at this time, I just feel that for him to feel safe and secure and to be happy and just to concentrate about schoolwork and doing his 9th grade work, I feel it's very important for him to stay in the one home until the courts can come to a trial and a final decision.
Okay. And I do see that you have also filed that order for adequate cause, which was granted to more permanently amend the parenting plan. Is that correct?
Yes, ma'am.
And you're just awaiting a hearing date on that, it looks like.
I think it's in May.
Okay.
So I guess I was hoping to have this restraining order in place until May, and then just go by whatever parenting plan we come up with.
Okay. Okay. Thank you for your input. Ms. Vianola, do you object to this restraining order being put into place temporarily?
Absolutely. 100%.
Okay. So let's go ahead and have you raise your right hand. You swear and affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Let's have you state your full name and spell your name for the record.
It is Melanie Rebecca Vianola. MELANIE REBECCA V as in Victor IENOLA.
All right, so go ahead and please tell the court why you are objecting to this restraining order being entered at this time.
I'm objecting to it because there is absolutely none of this it's never happened. There's actually a CPS report. Nothing was founded. This is the third CPS report that has been done on us, and nothing has been founded. And we are now going on our third guardian ad litem. And the first two were definitely not in the favor of what Mr. Derby's saying. And it's kind of the same thing, only it's progressed. The things he has now accused me of are heinous, absolutely heinous. I work with children, and I could lose my job had anything come of it for any reason. My son, I have not seen in over a month because he is not following the current parenting plan. So I don't really know why he thinks the paper today matters, or what he says matters, when he can't even follow the current parenting plan. That is a concern to me majorly, that not only have I not seen him, he's withheld him from my parents, whom they have wonderful bonds, and they've seen my son every other week for the past 8 years. And he has not been able to contact any of us. And I've also not contacted Mr. Derby since March 21st. And when I did, it was a message from the school about Driston using his phone. And it was just a photocopy of that and asked if he had seen it. I actually have my father here as well, because I think what's best for Driston, honestly, at this point, is to be out of both of our homes. And Mr. Derby said that my dad's house is a safe place. He loves his grandpa, and it's a mutual ground. And it's a place where Driston can be safe and feel like he can speak freely. And I hate saying that because as a mom, that's the hardest thing to do. But I don't think he's in a good position right now, where his dad has been keeping him from everybody and isolating him completely.
Okay. And I'll just state for the record, I won't be deciding any sort of alternative placement for the minor child at this point. That could be something that you address when you all go to a full hearing on any modification of the parenting plan.
Okay.
Anything else? Yeah. Anything else you want the court to know?
I mean, I really don't, that other than I know that everything he's saying is so not true, and it's slanderous. I've been defending myself for 13 years in this court system. That's all I've been doing. It's not about Driston and what's best for him. I have been defending my character and who I am, and my husband's character, and my oldest son's character. That's all this is.
All right. Thank you for your testimony.
Thank you.
Ms. Height, I know that you recently, at least based on my review, you had some interactions previously in this case and then were reappointed. And I know that was fairly recent, so I'm not sure how far that new investigation essentially has gone. So I'll turn it over to you at this point to see if you have any input for the court.
Thank you, Your Honor. That is the situation. I was originally appointed in November of last year. Adequate cause was not found at that time, and so I set everything aside. I was reappointed on the 15th of March and re-engaged with the parties to see if we could get some traction to get the intake packets returned. I had already received Mr. Derby's packet, and I've been assured in a conversation with Ms. Vianola yesterday that she's going to get that packet and payment to me so that I can get underway. I will tell the court this morning that in my previous appointment, I did speak with Driston at school, and we had a good conversation. He did express at that point some discomfort being at mom's home, but Driston he's a complicated and special young man. And I don't know if it was something that was bothering him that particular day. I got the impression that things change quite often with him. Seems to be a fair amount of volatility in the homes. And I think volatility is probably too strong a word. There seems to be some uncertainty and instability for him in his thinking and behavior in the home. So all that to say, I don't have any fresh information. I haven't talked to Driston since I was reappointed. And so hopefully that will get underway soon. My final report is due on May 10th, and I have every expectation that I can meet that deadline.
Yeah, and I do see there's also, unless this has been stricken for some reason, it looks like there is a compliance review set for April 12th. So just next week. Does that sound correct to the parties?
Yes, ma'am.
I've never been served with any papers of that, so I had no idea.
So this was set during a March 15th appearance where I'm just looking to see if you were present. It doesn't look like you were present.
I missed it because I received in my filed papers basically a judgment that had already been made is what it looked like, but it had not actually been filed. So I thought a judgment had already been made. My mistake for not looking further into that. But yes, I did miss the court date. So
yeah, and I would let you know what the court does have based on that March 15th hearing where you weren't present. They did set a compliance review for April 12 at 9 a.m.
Okay.
So that would be next, what is that, next Wednesday or Tuesday? I don't have a calendar in front of me. Next Wednesday. So this same docket at 9 a.m. next Wednesday.
Your Honor, I'm just wondering if, in view of the fact that I have spoken to both parties since I was appointed and have had assurances that I have one intake packet and I have assurances that I'll be getting the other one shortly. And I don't believe payment is going to be an issue either. If it would be worthwhile to strike that, I would say at this point, as far as we could have gotten by now, we are in compliance. And I don't anticipate a problem getting the other information that would be reviewed at that time, although I'm perfectly willing to come back next week.
Let's come back to that issue. This is what I couldn't see. I do see the order regarding adequate cause granted to send the parenting plan amendment to a full hearing. Has there been a date set for that full hearing? I know, Mr. Derby, you mentioned something in May, and I'm just not seeing that.
They said May 3rd, but I'm not sure if that was actually set in stone.
Okay, let me check with the court. Are you able to see if there's been a date set on that? The last thing I have is the March 15th order finding adequate cause to send to a full hearing, but it doesn't actually have a hearing date in there. Oh, before setting it. Yeah, okay. Right. Can we do that today? Or do they need to do a motion note for motion docket for that to be set? Whatever your preference is. The trial assignment, yeah. Okay, let's do this just because I think there is not a date set yet for that full hearing. And Commissioner Nelson would be the one handling the April 12th compliance review just to kind of make sure we're ready to go. Let's go ahead and keep April 12th at 9 a.m. I'm sure it can be, very brief, just to determine if we're ready to set that full hearing date. And then the parties would note this for an actual hearing date.
Just to see your son.
Okay. Now let's go to the restraining order. Ms. Height, do you have any input to the court as to whether a temporary restraining order would be necessary to protect the minor in the meantime? And I see that the court issued an emergency one. I'm kind of in a position where it's essentially he said, she said. I don't really have any documentation in front of me. So, I do see the prior parenting plan based on a full GAL investigation at that time did not put a restraining order into place. So, any thoughts or input from you?
I don't have any recent contact with Tristan, and this week is spring break. I would have preferred to speak with him at the school, but I think I would have a little more forthcoming conversation. So my hope is to speak with him next week. So all that to say, Your Honor, I don't really have any fresh information that I think would be helpful this morning.
Okay. Well, here's what I'm inclined to do. I think because the prior commissioner put an emergency order into place, I am going to temporarily re-up that until there can be further investigation. The reason I'm doing that, Ms. Pianola, is not in any way to say that I necessarily am making any ruling on the veracity of the statements that are made, but I do think it makes a lot of sense to have this further investigation and have Ms. Height be able to talk to the child before we make any permanent decisions on that. So what I'm going to do now is actually go back and reverse my prior ruling on that review date. I think what we should do is set out the review date a bit further, and then I'll make this restraining order temporary only through that review date. So it would essentially be a new compliance review date as well as a review of the restraining order. And hopefully at that time, we'll have a little more feedback as to whether this needs to be a longer term restraining order or not. So with that said, I'm kind of thinking 2 to 3 weeks at most. Ms. Height, what would be your preference?
Well, in view of the fact that everyone wants to get some stability for this young man, I think the 19th would work. If that would be 2 weeks. Yeah. And what I will attempt to do is have contact with him, and then I would like to file a brief written report, just really an information for the court so that everybody's on the same page when we come back on the 19th. So it might come in later than I normally would like to. I would like to file it 3 or 4 days ahead of time, and I will attempt to do that, Your Honor.
Yeah, that makes perfect sense, and I appreciate that. And I think, so Mr. Derby, Ms. Vianola, instead of coming back next week on April 12th, I'm inclined to strike that and instead reset this for review, both compliance and restraining order for April 19 at 9 a.m. Does that work for the parties to log back in here Wednesday, April 19 at 9 a.m.?
Yes, Your Honor.
Okay. Ms. Vianola, does that date work for you?
I mean, I haven't seen my son in over a month. Is there any way I can do a supervised visitation with him with a mutual or a parent's place? I think it's really difficult to say that it's fair to Tristan or to either one of us that he hasn't seen me, and not just a month, that's just been solid, has not seen me, but it started 6 months ago. Yeah. And now this is actually my spring break. And that's a long time not to see your mother and be isolated from both parties. And now I can't have any contact with him without any valid, even a CPS report was done and nothing was found of it. So I
And
just
Mr. or excuse me, Ms. Vianola, does Driston have like FaceTime capabilities on a phone or some other electronic device or a device that he could access? Because I am inclined to allow electronic communication, because then I know that it's his wish to, reach out to you. And I think
Right.
that's very valid for the next
in our
2
parenting plan, he does have that right. Unfortunately, I don't get to talk to him on the phone. I only get text messages, and I know how Driston speaks, and it is not Driston. I can't guarantee who I'm talking to, and he hasn't called my parents. He hasn't called anybody. So I have a hard time believing he has free access. Mr. Derby will say he does,
Okay.
but I can't guarantee that.
So Mr. Derby, what I am inclined to write into this very short-term 2-week restraining order is that all forms of electronic and phone and video communication will be allowed. And I really do recommend that you allow that to occur, and that you allow that to occur privately, where you're not standing over the child and the child doesn't feel like they have to please both you and Ms. Vianola, that this is time with his mother. Is that something that you can make sure happens?
Yes, ma'am. He has his own telephone and his own number, and she has it. I ask him all the time if he wants to call his mother. He says no. He absolutely does not want to. I'm doing this for him. In the prior cases, he's been so young that he wasn't able to really say what he wanted. And now that he's actually getting older, this is why this is occurring again, is because he's actually able to tell the truth of what's going on. But he has his own phone number. He has it with him 24/7. So even at school, he has it for any kind of an emergency calls. And everybody has his phone number.
Okay. So I am writing that specifically into the order. So Ms. Vianola, all forms of electronic communication, including phone, text, email, FaceTime, those are allowed. And I would encourage the parties to do that, to keep that parent-child connection through this rocky 2-week period that, we will get through. And we'll be back here on April 19. I'm going to finish filling out this order. Just hold tight with me in case I have any questions for you.
I do have a question while you're doing that really quick. Would it be possible to meet at his school during a free hour with his caseworker during the day? If it's a free hour.
And someone's trying to speak over you.
I hear that. Sorry.
If you're not actively in front of this court on a case right now, please mute. Otherwise, the court will mute for you. Go ahead, Ms. Vianola.
So I know Mr. Langenbach is his caseworker at school. I know he has 2 periods, or he was having 2 periods with him. And he also has a counselor that I had, asked them to kind of check in with him periodically because of everything. Is it possible that I could meet him at the school with the counselor? And if it's a free time, lunchtime, if that is something he would like to do during these 2 weeks, I don't want to step boundaries where I don't know what my restraining order is, other than I can't be within 50 feet of him.
Yeah, I think what I understand what you are asking. And I think just for this 2-week period, I'm going to leave it as no in-person contact until the court has a better idea of what exactly is going on here and what the wishes of the 15-year-old are and what the concerns potentially are. So hang in with us for these 2 weeks. I'm going to put in the exception for electronic communication, but I'm not inclined to do any in-person contact at this time.
I want the courts to really know that Driston, you know, he is, like the GAL said, unique, and he's functioning not at a 15-year-old level. He functions at a
Away
6th grade
from me.
level. And his doctor's notes say that, his teachers say that on the new IEP we just did. So it's very important to remember that, yes, normally a 15-year-old, you know, can be very capable of making these kind of decisions or understanding things. He is not 100% there.
Oh boy, see, this is why he needs to get away from her.
I don't find it funny. Sorry, Mr.
Oh.
Derby.
No,
I'm
it's
gonna have to meet some folks here.
I already filed it all.
Okay. And again, I certainly understand the concerns. I do hear you. It's not falling on deaf ears. I just, I think that given where we are at and the fact that we can get you folks back in 2 weeks, I'm just going to leave it as is now with electronic, phone, video, all of that. Strongly encouraged, allowed and strongly encouraged. So Mr. Derby, I hope you're hearing me say that I am hoping that Ms. Vianola and her son do stay in contact electronically through this 2-week period. I think that will be important for both of them.
Thank you.
And then I'm going to check the box on this, that because you were both here, although virtually, that this restraining order doesn't need to be served on you, Ms. Vianola, by law enforcement. I think that's kind of overkill in this situation. But what I would encourage you to do is anytime later today, reach out to the clerk's office or come by the Superior Court clerk's office and get a copy of it.
Okay.
Because then if any issues come up with, was electronic communication allowed, that sort of thing, you're going to actually have that in hand.
Okay. Thank you.
Oh,
Yes, sir. I saw you raise your hand. Go ahead.
I was just was going to let the courts know that she was served by the sheriff's department.
And sir, what I'm talking about is this order that I'm currently signing. This one is a little bit different than the urgency order that Commissioner Nelson signed, because it does allow that electronic communication. It also gives a specific expiration date of April 19, 2023 at 9 a.m., which is when you folks will be back in front of this court. And I will make sure that Commissioner Nelson, he will see it in the notes, but I am going to shoot him an email just to know that this is also an issue he'll need to address on April 19th if this restraining order needs to be re-upped, because the default is going to be that it lapses on April 19th at 9 a.m. Okay, I have got this filled out. I'm going to hand it up to the clerk. And just so I make sure we send it to the right law enforcement agency, Mr. Derby, what are you in Longview city limits? Kelso?
I'm in the Kelso area.
Okay. Are you in city limits or sheriff?
No, I'm out past Ostrander.
Okay. Would that be the Cowlitz County Sheriff? It is. Okay, perfect. All right. And then, ma'am, these are really odd questions, but in these restraining orders, they require we enter some identifying information. So hair color, I'm guessing brown, but might be red. So tell.
It's brown.
Okay. And then what's your eye color?
Brown.
Okay. And general height and weight, very awkward things to talk about.
It's okay. I'm 5'3" and a quarter. And I weigh about 155.
Okay, I've got that filled out. I'm handing that up to the clerk. I really appreciate everyone's time and patience. We'll get through this. We'll get you guys some resolution, some stability, some finality. Okay.
Thank you very much.
Your Honor.
Thank you.
Yes, go ahead. Yes.
Might I ask the parties one quick question, just kind of a housekeeping?
Of course.
I have a phone number for, I believe it's Tristan's phone number that ends with 2399. Could somebody verify, either one of you verify that for me? It's an old number and I just wanted to make sure I had it correct.
I think that was the phone number we had for him.
Okay.
Let me see.
And if you don't want to say
His-
it publicly, you can text it to me.
Thank you.
Well, good, Ms. Hyde, I'm glad you asked that question because it sounds like that information needed to go to all parties. So thank you.
That's not true.
Okay, if there's nothing. Mr. Derby, did you have something you wanted to say? To
I
the
just
board?
wanted to say that everyone has had his phone number. That's all.
All right. All right, parties, thank you for your time and you're free to log out. And we'll see you back on April 15th at 9 a.m.
Thank you.
All right, we'll start at the top of the docket. So Donald Derby and Melanie Vianola. See Mr. Derby here. His height is,
I'm here, Your Honor. Melanie Vianola.
oh, there we are. Okay, great. All right, I've signed an order for adequate cause, which we'll talk about at the end in terms of getting that to a hearing. There's been a report from the guardian ad litem, and I think today we need to look at what kind of parenting arrangement we'll have until we get to the hearing on the adequate cause. Mr. Derby, let me hear from you first, and then Ms. Height, and then we'll go to Ms. Vianola.
Good morning, Your Honor.
Good morning.
I'm hoping that my restraining order will stay in effect at least until we get some finalizing orders from the court. He seems to be doing so much better. He's happy. He's begging to stay at my house. I just feel like right now he's been at my house now for over 2 months and he's really adjusting well. He's liking our routine. So I just hope that the courts will see that Tristan should stay with his father at this time. After he made that CPS report, his relationship with his mother got very volatile. So I'm just concerned. I don't want to see him go backwards.
All right, thank you. Ms. Height, do you want to weigh in?
Yes, good morning, Your Honor.
morning.
I put a couple of recommendations in my report, as you saw, and I do think that it is probably short-term in Tristan's best interest to remain where he is due to some of the disarray that's going on around him right now. I do have some other things I'd like to address with the court as I proceed with my investigation, but I think I'd like to hold off on those comments until after you've had a chance to hear from Ms. Vianola.
Okay. Ms. Vianola, any response?
Yes, Your Honor. I have not seen my son since it's been 2 months solid, and that was prior to a no contact order. And I missed a court date, which is obviously a horrible thing to have happen. And that is when I believe the no contact order came into play. But I don't understand why there was even a no contact order put into play, because I hadn't spoke to Donald via text, phone since March 21st, and it was about an email from the school. And that was the last time I contacted him. So also the CPS report, there's no findings. And this is the third CPS report that he has filed against me. Well, one against my husband that was very, very awful, as well as the one that he claims on me. And there's no findings and no details. And the only thing I can really 100% say about my son is if something happens to him, good or bad, he knows detail for detail, and that could be 10 years ago. He knows what you're wearing, what he had for breakfast. He is very, very meticulous when it comes to things that happen to him specifically. So I don't know how he can continue to violate the plan over and over and get basically rewarded for that. I mean, that's how I feel. He's had no consequences. I don't know what to file. I knew we were going to court, so I knew all this was going to come out. So I really just don't know what to file to say, look, he started this. December 8th was the first time that he started the withholding. And it turned in from just my weekends to solid 2 months. And then all this stuff happened. So I personally believe that Driston would have a better shot if we both were supervised during this report and Driston went and stayed with my father, who is a mutual person that Dawn feels is a safe home. Driston has a great bond with. And we be supervised, because we've had 2 other GAL reports and nothing has changed, and except that things are being aggressively worse towards me, like I'm becoming a more and more horrible person. It's not about Driston anymore, is how I feel. And that's it.
All right.
My father is here too as well, if you would like to speak with him at all.
Okay, I'm going to go back to Ms. Height first. Ms. Height.
Well, my comments now, Your Honor, are related to my concerns as the new GAL going forward. As Ms. Vianola just mentioned, I am now the 3rd GAL that the court has appointed. As you can see by the date on the docket notice there, this case has been going on now for 10 years and 2 months. And as I looked back over some of what's gone on before, I have not had time to read all of it, but I noticed, I made notes that there have been parenting plans, temporary parenting plans, amended parenting plans in 2013, 2014, 2015, 2019, 2021, and now here we are in 2023 with currently a 50-50 plan that it doesn't seem to be working. The record is littered with contempt allegations and charges. There's currently, as you know, this restraining order in place. There have been CPS reports, there have been allegations, accusations, denials throughout the pendency of this case. I have not read all of it yet, but of course I will. During all of this, we have now Driston. He's 15 and a half. He's a special boy. He has an IEP at High for academics and for behavior. He is by all accounts doing well in school right now, but he has seen and heard an appalling amount of adult conversation and frankly parental dysfunction over the length of his life. So as I approach this case, Your Honor, I believe that what I need to do in order to proceed and have a thorough, fair, complete investigation and a report for Your Honor is, I believe after looking back at what we have up to this point, we need a level playing field here. And so this morning I'm asking for 2 things from Your Honor. First of all, I would like to have both parties have, by the end of today, I'd like to have them both go have a hair follicle 12-panel test with alcohol ETG. There have been allegations about drinking and fighting, and it seems like that's related to fighting. I need to know what's really going on. So I would like the court to order both parties to have a hair follicle 12-panel with ETG and no alteration of hair between now and then. Second, I would like them by end of workday tomorrow to both have made appointments to get a mental health evaluation with collateral input from me. I'd like them to sign ROIs. They can do that at Core Health or Columbia Wellness or wherever they would like to, but I would like to know that is underway immediately. The hair follicle test can be done over, there's the place that I believe can get to it right away would be occupational health over across from 15th Avenue Safeway. I pondered this morning whether there should be domestic violence evaluations, and I'm going to hold off on requesting that at this time. But I feel, Your Honor, that in order to do a fair evaluation, I need to get all of us on the same page. So those are my requests this morning, Your Honor.
What would be your thought of having a visit with the mother supervised by her father?
I am in favor of that. Driston is not. As you noted in my report, he said some rather, I would say, severe things during our interview. And I tried mightily to get some variation or some change on that. And that is one of the things I suggested to him and wondered if that would work. He adamantly said he did not want to do that. I personally feel like it's good for kids to have contact with both parents, and I would like him to do that. However, he was very, very stern about what he wanted and did not want. In fact, he did not want to have, even though I recommended it at the end of the day, he did not want to have phone contact either. And so I haven't been able to dig into the bottom of even why he feels the way he does, what's been going on, and what needs to be addressed. So I feel like it's a good idea. I don't know how to make that happen without creating a bigger problem for him. He has been through a lot for a long time, and I'm very concerned about that. One last thing, Your Honor, before I let this piece go is, I know we are due for my final report on May 10th, and I don't think it's reasonable if Your Honor orders the things that I'm requesting today. I don't think it's realistic to expect that to be done and a report to be done and filed in a timely way. I'm going to ask for a delay of probably more realistic than a month. I probably should ask for 45 days beyond May 10th, which would put us more toward the end of June. And it bothers me. When I was talking about a May 10th deadline, it seemed like a more reasonable thing to say, well, let's just leave things as they are until May 10th. But when we're going all the way another 45 days past that, I do think that's an additional very long time for a mother not to have contact with her son. So that's the dilemma that I find myself in this morning, Your Honor.
All right, thank you. Mr. Derby, I'll give you the last word.
I have been trying to ask him if he wants to call his mother or his grandparents, and he's really, really adamantly just does not want to. And I don't know, I don't feel like I can force him to do it. You know, I've left it for him. He has his own phone. And talking about his own phone, last court, we both took an oath. We raised our right hands and said that we would tell the truth. And she said she had never talked with him at all and didn't even know his phone number. And that was false, because they'd been having text messages back and forth and talking, and he'd been calling his grandparents. So I just wanted the courts to know that too, on top of everything else. I felt
Recently were those contacts?
Excuse me?
How recent were those contacts by text messages?
Just before we started the adequate cause.
Oh, recently then.
Mm-hmm.
Okay.
And I think I asked him, I said, did you show your phone? You know, because I wanted him to show the phone so that way maybe the guardian ad litem could see that he had been in communication, and but his mother said that there was none and that I was keeping him from her, and that wasn't true. He has his own phone. He takes it to school. He has, he can do whatever he wants with his phone. So I just wanted you to know that. He is definitely really concerned about being with his mother. And I don't know, there might be a lot more to this than what I even am aware of, because sometimes he's so resilient that sometimes he won't say something because he doesn't want to get someone else in trouble. He's a very nice boy, and I just feel like there's been more to this than what he's letting me know.
All right. Eventually, the contact with the mother may need to occur through some formal reunification counseling. And I'm sitting here, and part of me thinks that I should just require that there be a few hours of visitation during the week with the grandfather involved. But I think I've heard enough today that I might do more harm than good if I do that without some sort of formal counseling to get to that point. So I'm not going to order in-person visits. I am going to require, and this is going to be required on Tristan's part, one telephone call a week to his mother. And you can tell him the court is requiring that. Okay. And, let's make it Thursday night at 7 p.m. That shouldn't get in the way of much in the way of people's activities. So I would like the message to go to Tristan that that's what I want.
Your Honor, I'm sorry to interrupt, Your Honor, but since Tristan and I had talked about this at a recent interview, would you allow me to notify him today of that?
Yes, you may do that.
Thank you.
And he has his phone on at school, and just so you know.
Okay.
And tell him they've got to chat about mundane things for at least 5 minutes.
Okay.
What's going on at school, what's happening here. I also want to make sure that parents have contact with their children, but I want to be safe about it. Let's go on to some of the other issues. First of all, I'll have Ms. Hyde's final report due on June 28th.
Okay.
Secondly, I am going to order the evaluations that she has requested. So that means today both parties are to get a 12-panel hair follicle test with an alcohol component. And by tomorrow, a mental health evaluation, if you can get in to do it at either Core Health or Columbia Wellness. Indicate that these are court ordered. Okay. Finally, has this been put on the trial setting calendar to get a trial date for the adequate cause hearing or the new parenting plan hearing? Mr. Derby, do you know?
I'm not aware of any new.
Okay. So what happens after I find adequate cause is that you go to the trial setting calendar and set a trial in order to relitigate the parenting plan. And that will be 6 to 8 weeks after you go to the trial setting conference. So I'm going to require and have everyone show up on the trial setting conference on May 10th. So Wednesday at 1 p.m. And it will be for a 1-day hearing regarding your parenting plan. And that will need to be set after June 28th so that Ms. Height can complete her investigation.
Okay, Your Honor.
Now, the final thing I'm going to do, I'm going to set a review before this court on May 17th at 9 a.m. And I'm going to inquire. There's going to be one inquiry from me, and that is after several phone calls with Ms. Vianola, is it possible to have supervised visits after that date? And I just want to check in. I think going from now until likely sometime in July is a long time for Ms. Vianola to not see her son.
I agree.
And I want to be sensitive to what Tristan wants, but I'm thinking if they have a few phone calls, maybe that will change. Also, there's some concern raised about making disparaging remarks to Tristan about the other parent, and that cannot be done. And if I hear of that again, that's going to be a significant concern. Okay.
Your Honor, if I might just trouble you for one more thing.
Sure.
Would you remind the parties to sign ROIs for both of those services? And if they would text me and let me know when their mental health evaluations are scheduled for, that will help me to plan the timing of my investigation going forward. I know those are small housekeeping details, but I think they'll be helpful for me. Thank you.
So at where you get the hair follicle test, you'll need to sign a release of information. We call it an ROI in favor of Ms. Height so she can get that document. And when you do an evaluation at either Columbia Wellness or Core Health, you'll need to sign a similar ROI. Okay. And then let her know when those are completed. Anything else, Ms. Height?
I think that's it this morning, Your Honor. Thank you very much.
Mr. Derby, anything else?
No, Your Honor.
Ms. Vianola?
No, that's it. Thank you, Your Honor.
All right, we'll see you back here then on May 17th.
Thank you.
All right, Derby versus Vianola. It's Donald Derby and Melanie Vianola.
Yes,
Yes, Your Honor, Donald here.
Okay, good. I'm glad everybody's here. Last time we were together, I requested both parents do a hair follicle, 12-panel hair follicle test and do a mental health evaluation. That was at the request of Ms. Height. Has that been done at this point, or is that in process? Ms. Vianola, do you want to respond first?
Sure. I spoke with Anne and I called the places just to check the two that were recommended, and they don't do court ordered follicles, but I have psoriasis of the head, and she was okay with, I have been seeing Metrics Clinic for the last 3 years, and I have not had one dirty UA in about 3.5 years. She said she was okay with me releasing that as a means of providing a UA, and then so I have been seeing a psychiatrist and already have had mental evaluations, which I released that to her, or released that information to her too. So she was okay with that. I hope that's still okay, but that is what I've done.
Mr. Derby, have you been able to take care of those requirements?
Yes, Your Honor. I went to the Core Health here in Longview and also the occupational health for the hair follicle, which is in Longview too.
Okay. Ms. Height, do you want to address those requirements?
I would like to, Your Honor, because my evaluation of it is a little bit different than what you've heard here this morning. I did talk with both parties about it. As you recall, when we were in court last time, my concern was that those would be taken care of, and your order was that they would be taken care of by end of business the following day. That was not done. Part of my major concern on this is the alcohol use of the parties, and that needs to be done immediately after your order. It was not done by either party. And in fact, that is Dristen's main concern with me, is that when alcohol is consumed, which sounds like it is somewhat regular, it affects his relationship with the family. And he has, in the interim between our last visit and now, re-stressed that with me. So I did speak with both parties, and Ms. Vianola is correct. She shared that information with me. I was not okay. I agreed that that's was the information we got, but I did not agree that it was adequate. For one thing, and I understand that she has scalp issue. However, we call this a hair follicle test. It is really not hair that's taken out of the head, is usually an inch to an inch and a half that is cut. So there's no real impairment of the scalp. It could have been done. She chose not to do that for her own reasons, and I think that's information for the court to evaluate. Again, my concern for both of these parties, as much as the hair issue, was the unannounced observed UAs, and those have not been received. In addition, the records that have been referred to, I have not received anything from either party. I take that back. I did receive yesterday, I received the follicle or the hair report from Mr. Derby, which came back with marijuana use on it, but nothing else. As far as I know, he didn't do anything with the alcohol. Although when I spoke with the provider of the follicle, I said, there's really no point if they haven't been in there by the end of business on the day that you prescribed, which they had not. I didn't see any point in that at that time of doing a UA, because it does not provide that immediate information that was so critically important to me. And my frustration is that you asked for 3 things and nobody really did all of them. The other thing that I think is of interest is that the other thing you asked for was that Dristen engage in some phone conversations with his mom. And I've talked with him since our last visit 3, maybe 4 times. I visited him at home, and I've talked with him on the phone several times. And he has made some of those calls. He admits he didn't make every one of them, and that they've gone okay. He was quite specific with me when I spoke with him yesterday, that he wanted to keep the phone call visitation as is. He does not want to move forward with other visitation. He and I talked at some length about various options, and we made a kind of a temporary preliminary list of things that would help him feel comfortable having in-person visitation. And in fact, he did have an in-person visitation with his grandparents over one of the weekends here recently, which he said had gone well. But at this time, he wants to leave things as they are, as the other parties have basically not done the most key piece of information that I wanted. I'm inclined to follow Dristen's request and leave things as they are until we can get some unannounced observed UAs. As I stated before, that has been his major issue regarding why things do not go well at home.
At his mother's.
I would also like to say, Your Honor, that in my conversations with both parties, they have been cooperative. They've been forthcoming. I think that there is some information that has not been given to me or hasn't been given to me correctly, and that's going to require some more digging. but I personally have found them to be cooperative at this point. I think I'm not hearing the whole story and the true story every time, but nevertheless, I think we can move forward and get the information that the court's going to need for Driston.
All right, Mr. Derby, why don't I hear from you first? Any response?
Yes, Your Honor. I went to the Core Health and did my medical evaluation that following week. And then the next was the hair follicle, and it was $125. And I had to wait a few days to take that. So I took it right away as soon as I could. I don't know if there was, I given all the ROIs to Anne, so I don't see where I didn't follow anything. And I was under the understanding that as long as we did it before May 17th and had the information, then we would be okay. So I didn't know why I was being in that type of like I was being put in that category.
And you know when the mental health evaluation will be completed from Core?
I've already completed it, Your Honor.
I know you've done it, but they have to do a report, I think. Have they indicated when that would be ready?
The doctor said that the ROI was released and that Anne could receive the information whenever she wanted. So
Okay.
that's all. And then I just left the facility. I just was under the understanding that Anne was going to go get the information. I gave her the doctor's name and the phone number, but I didn't think I needed to do anything else.
Okay. All right. Thank you. Ms. Vianola, any response to what Ms. Heide said?
Well, I mean, I completely disagree with this isolation that has gone on for now. We're talking 6 months, 7 months. I haven't seen Driston, and only one time has he initiated a phone call, and his dad is always in the background. And I can hear Dad talking. And the first time we talked, he was telling me all about his week because I'm to a guideline of a few things that we can discuss. So I can't talk about futuristic things because I don't know what the future holds. But he was excited to tell me about ceramics, all this stuff. And then the next week I had to call at, I believe it was 7 o'clock I had to call, or 6:30. Our time, I think, is 7. I'm not sure. Can't remember exactly, but in between those times. And he sounded like he was not interested in talking to me whatsoever. And 100%, I believe that my son has been given complete control now to the person who has been parent alienating him from me for the last 2 years. I mean, and it's unfair that, you know, okay, I misunderstood that Anne took that as acceptable. I did understand within 24 hours I needed to do something. I did contact Core Health and Columbia Wellness. Both of them said they do not do court-ordered hair follicle tests. So I did look around. There is one place in town, it's Peace Health or something, and it's $300 and some. And financially, after paying as much as I have in the courts and everything, we just don't have the money at 24 hours like that. I mean, we just don't. After lawyers and everything, I can't at the drop of a hat do that. I could do a blood test at my, through insurance. I could UA through my insurance in 24 hours, but that kind of money out of pocket, just I can't afford anymore.
Did you go to Core Health for the mental health evaluation?
I have gone through Family Health Center, and I didn't know that by just releasing the ROIs, I should have that printed up or something printed up and sent to Anne. So I did release all of my stuff after she did the home visit. I see Carla at Family Health Center. So to me, I didn't see why I should have to redo a mental evaluation when I have been seeing somebody currently and in their care. They do mental evaluations, but you don't get in right away with Core Health, even if it's court ordered. I called and I asked. So that I do know for a fact. So I don't know how that would have been either possible for either one of us to do within 24 hours, since neither one of those places do it. Also, Mr. Derby texted me on May 9th. And this is pertaining more to the no contact order with my son that has no backing or reasoning for. But he contacted me 19 times. He told me he went to OSHU, already got his hair follicle test. It cost him $500. And he was telling me what I needed to tell my mental evaluator. And that started at 5 o'clock and it ended at 8 o'clock at night. This is what he does. And I'm not allowed to even call my son, but he can contact me nonstop. And I've never been able to get a no contact order or anti-harassment order against him. Never. They've never granted me one. So that's really my thing, is that my son was taken out of my life in contempt of court, where he had no, he didn't get in trouble for any of that. He got rewarded by me losing all rights to my son and only getting a phone conversation that doesn't even happen, and it's not in privacy. So Driston is not going to be able to openly talk to me. And he went to my parents' house because Mr. Derby knew we had court. And that's what he does every time we're in court, is he sets things up. I know this sounds like I'm attacking, but we've done this for 13 years. It's a history. It's a pattern. He sets it up. He starts doing what he's supposed to look good. And then the second the court's not involved, he does not care about the parenting plan. He does not care about any rules or the court judgments. And he does whatever he wants. And somehow I have followed the best I can, except one thing, and I've lost all my rights for nothing.
We talked to Ms. Height again. She indicated she would do an ROI of her, I guess, counseling records. Is that sufficient, or do you still want her to do a mental health evaluation, either at court or Columbia Wellness?
It would probably be helpful, Your Honor, to see how recently those were done. And I'm certainly willing to consider that. I don't have to have it my way exactly. But I've not received any information of who to contact, how to contact. I did get, as Mr. Derby indicated, I did get a phone number, but I have not received any subsequent information on his evaluation. And it may not be ready to be dispersed yet. I don't know. It was done. I've got the date here. I believe it was done fairly recently, so I'm not surprised that I haven't received it. I would like to beg your patience to discuss the phone calls just briefly again.
Okay, go ahead.
When we talked before, our intention was that Driston would initiate these phone calls and that he would have a way of showing that he was engaged in doing this. And I still think that's a good idea. And having spoken several times to him, I think that he's capable of doing that. When he did not do them in a timely way, Mom understandably initiated the calls. And I think it would be worthwhile to see how he can do without anybody else initiating the calls. And so I would request that we tighten up some of the language on this and ask that my request would be that we continue with the weekly phone calls and that Driston be required to initiate those phone calls and that Driston be required to do it in a place and a time in which there is not oversight by Dad or anyone else. If that just means going outside and doing them at some other time, I mean, he should be able to figure that out. We had him on a certain time for a good reason to do him Thursday at 7 o'clock. That seemed like it was going to work for everybody. There may need to be more flexibility in the time frame of doing them. But what I want to see is Driston taking the initiative, Driston doing that and feeling like he has some agency here, that he can make some headway in having some say so. And so I feel like that's one thing we can keep trying to do. Meanwhile, as I said before, there's some shortfall in what's happened on both of the parents' apart. And I think basically they've chosen to misunderstand or chosen to forget when it's convenient, to be very frank with you. So I would still like to see Driston initiate those calls, and I'm certainly willing to contact him again. And I feel like he and I have had good conversations. And he's been forthcoming with me that he hasn't done them all. But he said when I talked with him yesterday, he said he was going to get on board and do those. So I know it's hard to be separated from him, and it's going to be a process to get him reintegrated, but he's very agitated right now about visitation. So I would like to see him allowed to initiate those calls and see how they go.
Okay. Thank you, everyone, for your input. Let me just remind everyone that you have a trial set the week of July 3rd, and there'll be a readiness hearing before that. So that's coming up. I'm going to order that both parents complete a UA by tomorrow at 5 p.m. And if that wasn't exactly clear last time, I want it to be clear today. If it's not done by 5 p.m., then that's a factor that's going to enter into the court's decision making when it comes to addressing custody and visitation. Secondly, I'm going to take Ms. Height's recommendation. I'm going to order Driston to initiate the phone call to Ms. Vianola. I'm going to leave that every Thursday at 7 p.m. Mr. Derby cannot be within hearing distance of that phone call. And that phone call will last as long as Driston wants it to last. Okay. And I think I need to set a review here fairly shortly. So I'm going to do that on May 31. I want to confirm that at least 2 phone calls were initiated by Driston and that they were productive. And I want to confirm that the UAs were done by May 18th at 5 p.m. If those things are not happening, then I'm going to be seriously concerned. Okay.
Can I ask one thing, Your Honor?
Sure.
Anyway, since a phone call is essentially the same as a video phone call, is there any way we could do that? So that way I get the security of knowing he's outside or nobody's around him. I know that because I know his dad's not going to allow it and I can't prove it. I mean, how do I prove something that I know in my heart, because I know the meat of our life, that he is not going to allow him to have private conversations with me. So maybe if the times maybe on a lunch break or somewhere where he's not in dad's possession, I guess I could say.
Well,
I know that's difficult, but
the problem with making it whenever it's convenient or whenever dad's not around is my experience is that then it's not going to happen. And if we have a specific time and specific date, then it's more likely to occur. Secondly, I'm not going to assume Mr. Derby is going to violate a court order at this point. If he does, then that's going to create some other concerns. And I'm going to let Driston decide if he wants them to be, on FaceTime or some other video setting. You certainly can talk to him about that. But I'm gonna let Driston have the decision on how he wants that to occur.
Your Honor.
Yes.
Your Honor, as you allowed last time, Can I notify Dristin about this? And I know we don't like to talk about court action with kids, and I try to be super careful about that. But I would like to be able to tell him that this is court ordered by Your Honor, and it was done today, and that he is to be separated from his dad during these conversations. I
And
believe he can be responsible to do that, and I think it would be good for him to exercise his responsibility to make sure that that's happening. But I guess I would like authorization from you to be able to give him those details from today's court hearing.
I think that should come from you rather than anyone else. So yes, I think you should inform him about that.
Okay.
And then we'll be back here in 2 weeks and see how that went.
All right.
Thank you.
All right,
Thank you,
you
Your
will
Honor.
be back here on the 31st.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Let's go to Donald Derby and Melanie Vianola.
I'm here, Your Honor.
I'm here, Your Honor.
All right, good. And looks like Ms. Hyde is here. So did you get the report from Ms. Hyde?
Yes, I did.
Okay. So looking at the file, it looks like you're going to trial on the week of July 3rd. It looks like Dristin made one call on May 18th and did not make any other calls. There was some indication that Mr. Derby was close by during the call, which was not what I had ordered.
No, Your Honor.
Let me tell you what my thought is here, since we're coming up on trial in a little over a month. And since Dristin has indicated a reluctance to talk to Miss Vianola, at this point, my intent would be to leave the telephone calls required every Thursday, that Dristin initiate those and Mr. Derby not be in the vicinity when those occur. And then you'll need to go to trial to get a more permanent order relating to the parenting plan. Any response to that, Ms. Vianola?
Absolutely. I have not spoken to my son, but one time, or I'm sorry, twice now. And both times Dad was there. And the last time I spoke with him, spoke about.
How do you know Dad was there?
I can hear him. And then after I spoke to Dristin for about maybe 5 minutes, if that, I said, well, can I talk to your dad? And he just basically handed the phone to his dad. And Dristin told me, that's my dad watching basketball. He does not have the wherewithal to go outside, because as much as Dawn says it's Dristin's choice, it is not Dristin's choice. I think our parenting plan that we have now currently has been 5 years, a little over 5 years. Dristin has never made one phone call to our home from his father's house, even though he's supposed to once a week. And that's because he doesn't get to make choices. It's always Dad telling him what he can and can't do. And he's not going to disobey his father. And the other problem I'm really having with this is that I lost all contact with my son completely while Dawn was in contempt of court, and he went and got a court no contact order, which got him out of trouble of not following the parenting plan before any of this started. And now Mr. Derby and I had started talking about a parenting plan, working on what was best for Dristin. And he put in that parenting plan, he has zero cares or concerns of neglect, abuse of any form in my home. Yet he called CPS and reported I beat him immensely. Like, I just can't even believe that another parent would make something up like that. But now I am safe and I am secure to have my son in my home as long as I sign the parenting plan that him and Driston came up with. And I feel like I'm being blackmailed because I haven't seen my son now or talked to him in going on 5 months. And I didn't do anything to get him taken away. CPS had no finding. And I don't even get supervised visitations, and I did nothing wrong. So, and I've said that almost every court date. And I don't understand how Dawn can say, I'll get rid of the parent or the no contact order if you sign this piece of paper. But I can't see him, and I'm not going to talk to him on the phone because he's not going to call me and talk to me in front of his dad or have a normal conversation. And our relationship wasn't broken until the courts continued to allow this to go on. So I have some serious frustrations. Sorry if that comes off harsh, but I'm very, very frustrated because there wasn't a broken bond between my son and I. I had him every other week for the last 5.5 years.
Okay. Mr. Derby, any response to any of that?
Yes, Your Honor. For one, Driston has his own phone. He has it at school right now. I do not monitor his phone calls to his mother. Last Thursday, he did not make a phone call because the week before that, she had called him, said that she was going to agree with a 1 weekend a month parenting plan change. Then the following couple days later, she said she wasn't going to do it. So then my son got very upset, said, yep, my mom's lying again. And so then he did not want to call her. So, and I'm not going to force him to call her. He is very adamant, Your Honor, on there's something between them that has occurred that he just does not want to even look at her. And so, and I don't know. I don't know exactly. I'm sure Ann probably has more of that insight than even I. And also, Your Honor, as far as everything that the courts have asked us to do, the respondent has failed to take a mental health evaluation. The respondent has failed to take a hair follicle test. I have done everything the courts have asked, and I feel like she's not cooperating with the courts enough. And as far as Driston's concerned, he does not want to talk with her even on like a chat Zoom. So I feel there's something more serious than what she's acknowledging.
How does he not want to talk to her when it sounds like he was agreeable to a 1 weekend a month visit with her?
I believe it was because of her verbal agreement to him that she was going to agree for a new parenting plan, and he got excited. And then, like I said, a couple days later, she changed her mind, and then my son got upset, said that he didn't want to talk with her because all she did was lie to him. I do not sit by his room or anywhere close to him when he's talking on the phone, so I don't know where that's even come from.
Can I say something to that?
Let me hear from Ms. Height first, and then I'd like to hear from you. Ms. Height.
I detailed my concerns in the information I forwarded to Your Honor and to the parties. Hearing this morning and I haven't spoken with Driston lately. We've had a couple of brief text exchanges. When I spoke with him at his home, at his dad's home, he and I were talking about some options that he was interested in, and it was a fairly congenial conversation. We didn't come to any conclusions, and I let him know that I was not the one that made that decision, nor was he. Hearing this today, it sounds to me like Driston is way over involved in the moment-to-moment conversations and decisions that are possibly being made regarding a parenting plan. The fact that he talked about it one day and then 2 or 3 days later was upset because something had been changed. I don't believe that he should be involved in that level of participation. I think at his age, there are some things that he could be concerned about or be included, but this day-to-day back and forth is not good for him, and it's upsetting to him. I hear Mr. Derby's concerns about participation, and yet he himself has refused to follow your orders twice to take a UA. His response to me was that he would not take a UA until Melanie had her hair follicle test done. That was in total defiance of your orders twice. He also indicated that he would not believe a report of a UA from her because he felt like she would, as he put it, trick the system or trick the test. He's really been self-serving in that. And it concerns me that on the one hand, he is very, very interested in what she is doing, and yet he himself has not followed the orders that you clearly have stated twice. And it feels like Driston is being put in the middle, and these volleys are fired back and forth across him, and he is becoming collateral damage. I don't even know what to suggest going forward. I realize it's going to have to go down to a trial probably. I feel like Melanie has done what has been asked of her. We decided at the last court hearing that because the alcohol had been a problem, and the alcohol was what Driston was talking about as a problem, she did follow your requirement to take that test. She has not done the evaluation, but she had indicated to me and to you when we spoke about this in court of I don't know how many weeks ago now, that she was reluctant to do another evaluation because she had done one fairly recently, and I don't know when that was done, and that she would get that information to me. She has not gotten that to me yet, and I don't know if that's because the provider hasn't been in contact with me. I don't know where the break off of that was, but there is some information that's out there already. So it may be, given that information, that she doesn't need to do one. I just don't know that yet. I don't feel like her refusal to do that was a defiant act. I think it was more of a misunderstanding of how that information that's already available could get to me. So, and at this moment, I don't know exactly what that would require if she maybe hasn't signed an ROI, or sometimes the provider is slow getting it out. I just frankly don't know, but I do have some concerns. I am concerned that Driston, when I talked with Driston, he was amenable to having contact with his mom, to having phone contact with his mom, to having visitation with her. He also likes to visit with other members of that side of the family. And right now that's not occurring. And I think something needs to be done to reestablish a bond between he and his mom. And I think that can reasonably be done. I just at this moment don't know what the path forward is. He's a complicated and loving and lovable young man. And I really feel that he needs to have healthy contact with both parents. I just, I'm uncertain how to go forward. I understand you're thinking of staying with phone conversations until some further court action is taken, and that maybe that's the best we can do right now.
Thank you. Mr. Derby, excuse me, Ms. Vianola first, and then I'll go to Mr. Derby.
Well, as far as the mental health evaluation, I've been seeing a psychiatrist health center. I did sign the ROIs. I
Okay,
didn't understand that I needed to get them to her. I just thought if I signed them, she had access. So now that I know that, because I think that got cleared up when I talked or saw her text message the other day, that I can have that sent to her. And if it's not, up to date, I have no problem in going and taking another one. Already called and figured out. I just walk into Columbia Wellness and do that. So I have no problem with that whatsoever. But if what I have already, which is years of talking to somebody, might be better than just a new eval. But anyways, like I said, I have no problem with that. And as far as once I talked to Driston, and I believe it wasn't last Thursday, it was a Thursday prior, I have not had any contact, no text message to Don. I have not responded to his text messages. I have not responded to his mom's text messages about anything because I thought I made something really reasonable with Don, and it was every other weekend. And there's only 2 years left of holidays, every other holiday, 3 weeks out of summer if he had the majority of custody. And I think that's very reasonable. And it wasn't good enough. And nothing I offer is going to be good enough. And I don't think it matters what's on paper to Don. Don is going to do what he wants to do. And I hate to say that. And that is, yes, I did talk to Driston about what it looked like to him. I think I mentioned that. I normally never talk to him about anything to do with this because I know it's been a ping pong, and I've always felt that his dad is using him as a tool against me. There's been a lot of abuse between our relationship. It's why it didn't work. And I know he cares about Driston, but his meaning is he's trying to erase me and my family from Driston's life. Driston has had zero contact with my father, my biological father, and he used to spend every day after school with him on my weeks. Not one phone call or text message to him at all. And that can't be because Driston's choosing that. I just don't believe that at all because he has such a tight bond with all of us. And to not even talk about his animals. I mean, we have his dogs, a turtle, all these things, and he doesn't talk about any of them. And none of that makes sense to me other than somebody is implanting things in him. And the hate that Don harbors for me is unbelievable.
Let me hear from Mr. Derby. Okay, Mr. Derby, briefly.
Your Honor, I feel that I have complied with the courts. The biggest issue that we've had with the respondent is her drug usage. So I'm a little concerned with Ann's thinking on just alcohol with the respondent, because that was never the problem. The problem with the alcohol was when she mixes the pills and the alcohol. That's when the problem becomes. As far as Driston was just at her mother's home this last weekend. He spent 2 nights with them. He got to see his half brother. And I'm not telling Driston he can't go to any family members. I'm not telling Driston he can't call anyone. I don't know where this is even coming from. Everything that we're doing here with the courts is because Driston has asked. And this is why I've continually have come to the courts, is because of this continuation of the same problem. And Driston is the one that's suffering here. And what the last phone call he had with his mother was how he found out about the possibility of a parenting plan change. It did not come from me, Your Honor.
All right. Thank you both for your comments. There's still some information that I think Ms. Height needs. She needs to get the records from Columbia Wellness. That needs to be provided before the week of July 3rd, when this case will be set for trial. Again, going between now and July 3rd, And I'm doing this because I want to give Driston some sense of control over this. I want him to make phone calls to his mom every Thursday. I suppose if he absolutely doesn't want to do it, he won't. But I would like Ms. Height to indicate that the court would like to encourage that. In terms of what the ultimate parenting plan is, I can't require the parties agree to that. That's something that you'll have to, you can agree if you want, and sometimes it's better if you do, but ultimately you can bring that before a judge and bring that issue to trial. So,
Your Honor, we did make a rough draft for a new parenting plan proposal, which we gave her a copy of to see if she would agree to it. And basically, we wrote everything that Driston was asking for. He wanted 1 week in a month, and he wanted to see anyone on the holidays as he wanted to see them. Basically, I was trying to leave it to where Driston had more of the say in the new parenting plan.
okay. One of the things I'd like between now and July 3rd is to not have any discussion with him about the parenting plan. He's made his, I guess, his thoughts known to Mr. Derby at this point. If there is any discussion, it must be just between Mr. Derby and Ms. Vianola. So no discussion about parenting plan. Telephone calls are encouraged every Thursday, and the parties will go to trial again the week of July 3rd.
Can I ask something really,
Your Honor.
even sounds like you've made your decision, but is there any way that if Driston does go to my parents' house, that I can have at least supervised visitations? If he's allowing or okay with 1 weekend a month in a parenting plan that he rough draft up, is there no reason why I can't see him at my parents' house?
Mr. Derby, I'll let you respond to that, and then I'll go forward.
Well, Your Honor, the restraining order is in place because of the actions that the respondent has taken. I feel right now Driston would absolutely probably say no to this.
Could you explain that I did, Don?
But he does go and see her parents. I've asked him if he's wanted to talk or see his mother, and at this moment he's still saying he does not. I will definitely make sure that he calls his mother every Thursday, whether he likes it or not. I mean, I haven't been doing that, Your Honor, because I've been trying to let him just kind of become his own young man. He's going to be 16 here in a couple months.
Okay, let me address the visits with the grandparents. Again, I don't know enough at this point. I don't think the guardian ad litem knows enough to make a recommendation in that regard. So I'm going to have to deny that and hold that over to the trial.
Okay, thank you.
All right, thank you both.
Thank you, Your Honor.
Next, Donald Derby and Melanie Vianola. Are either of them here?
Yes, Your Honor.
All right, Mr. Derby is here. Is Ms. Vianola here? This is heading to trial on the week of July 3rd with a readiness hearing that you'll need to attend on June 27th at 11:30. Is there any reason why this case cannot go forward to trial at this time?
None for me, Your Honor.
All right. Ms. Height, will you be prepared for that week?
Yes, Your Honor.
Okay. And let me call out again, is Ms. Vianola here? I don't see her in the waiting room. All right. Well, this is just a check-in on for pre-trial. It sounds like the case is ready to go forward. So the next hearing date will be the readiness hearing on June 27th at 11:30. At that time, you will be given the exact date of the trial and probably the judicial officer who will hear it. Okay.
Okay, thank
All right.
you.
Thank you.
Ms. Height, I have you on number 1, Donald Derby and Melanie Vianola.
Yes, Your Honor.
Are you ready to have that case called?
Yes, I am.
Okay, we'll call number 1. This is 13-3001025. Do we have Mr. Derby present? And if so, can you unmute? And do we have Ms. Vianola present? And if so, can you unmute? Just looking through our system here. I'm not seeing either of those parties present. And I did sort of question if they would appear today, given that they just had a trial set for July 6th. So I'm curious if they thought that that canceled this review date. But Ms. Height, I'll turn it over to you.
You're correct, Your Honor, that we were just in court yesterday to set a trial for July 6th. At that time, it was noted to the court with both parties present that this was going to be reviewed today. So I know that they were aware that it was going to be happening. Excuse me. So that's precisely where we are at this moment.
Yeah, okay. Well, without them present, and we're, this just definitely wasn't the first case called. So, if it was 9:05, I'd probably give them a little bit more time. I don't want to hold up your day because I don't think I have you on any other cases.
I appreciate that, Your Honor. I believe this is my only case on this docket.
So what would be your request for today? I mean, normally if there wasn't a trial next week, we could set this over and give them another chance to appear. But trial scheduled for July 6th. So what would be your request of the court today?
I think realistically, this case is going to go to trial, and I think to let it play out on July 6th is probably the most efficient way to go forward.
Okay. I would agree with that. And I think what I'll do is just note, obviously, that the court did receive and review the GAL report timely. Ms. Height has complied with her obligations under this court's timeline. So I will also find that neither petitioner or respondent are here for me to make any or have any discussions about objections or agreements to the GAL report. So I'll just kind of leave that hanging in the air for trial. And we'll strike today's date and take no action.
All right.
Except to note that your report was timely filed.
Thank you. I appreciate that.
Of course. Anything else you need on this matter?
I believe that covers it, Your Honor. Thank you.
Okay. Thank you for your time.
The trial was held on July 6th as scheduled. Unfortunately, Odyssey gives us limited information about what was decided. We can see that an order to modify the parenting plan has been sent to court administration, but it doesn't tell us what they actually decided on for custody. I assume they figured out some sort of visitation for Mom. Whatever they came up with must be working out okay, as it's been 17 months since their trial, but they haven't been back to court for any new show cause or contempt hearings. I hope these parents have been putting their son's needs first, and I really hope they've stopped including him in discussions about the parenting plan. I wish them all the best of luck.